And then you're on a video saying this is the type of shit we do, roll up on niggas at the goddamn barber shop.
Studio microphone, all right. We're starting this video. I am in the middle of a judge already losing his patience. And honestly,
Same.
a man was just sitting in a barber shop, waiting for a haircut, minding his own business. And these guys walked in, attacked him, and then this is the part that gets me. They recorded themselves bragging about it on video, in a courtroom, with that video as evidence. Against them, we are off to a wild start. Let's break this down.
Kidding me. Are you in a gang or something? Is that what you did?
No, sir. So that's so much fun.
So why did this occur? I'm talking to you.
It was an incident.
Huh?
It was an incident.
I can't hear you.
It was an incident.
What'd you say?
It was an incident. Accident.
It was an incident.
Yes.
Is that your answer to that question? In this town, this is what you're doing? He's just waiting to get a haircut and you walk in, punch him, and say,
The co-defendant punched him, and he was, my client was videotaping.
That's how it's not, not this way.
okay, so this is on the law parties that he's here?
Yes.
Okay, so you're working with him.
Studio microphone, did you feel that energy shift? The judge just said, "Are you kidding me?" in open court and meant every single word. Now here's what you need to understand about what's happening legally. The defendant isn't even the one who threw the punch. He's here under the law of parties, one of the most important and most misunderstood laws in Texas. It means if you're present, participating, recording, encouraging, you are just as guilty as the person actually throwing the fists. Being the cameraman is not a get-out-of-jail-free card. Remember that.
This is, so this is on a video. You just walk in,
Yeah.
a person just sitting there waiting to get a haircut, and he gets pummeled. And then you're on a video saying this is the type of shit we do, roll up on niggas at the goddamn barbershop in this city? Are you kidding me? In this city? People, I mean, what kind of irresponsible behavior is that? And then the vulgarity. Do you find that odd, what you did?
Yes, sir.
We don't put up with this in this town. First of all, you start using the English language, not trash talk. That didn't get anybody anywhere. Look, I prosecuted the James Byrd murders. I don't put up with this. This is just vulgarity, and it's bigotry. And it's not sophisticated thinking. You understand?
Yes, sir.
What did we do with the other guy that was beating? Is he being prosecuted?
I have to look and see.
I think it's still,
the case.
I think it's still pending.
Don't know if it's even assigned to me, but I have to look.
Does aggravated assaults in broad daylight in a business where people are just trying to take care of their needs, and then y'all just walk up. That's your plan? You walk in and just start beating people senseless and then bragging about it?
Both minute is set for his initial setting on the 15th of April.
Here?
Yes, sir.
That should be interesting.
Studio microphone. Okay, this is the legal moment that changes everything in this case. The judge just explained the law of parties directly to the defendant's face. You film it, you plan it, you show up for it, you are it. No exceptions. And then comes the plea guilty, voluntarily, on the record. And State's Exhibit 1 is entered into evidence, which includes the defendant's signed confession that he is mentally competent, understands the charges, and is pleading guilty of his own free will. Once that exhibit is in, there is no going back. The case is essentially sealed right there.
You better fix this. You understand?
Yes, sir.
Don't do anything like this again. Act responsibly. But follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
This is what this city stands for. In this county. We're better than this.
See this one.
How do you plead in this? Guilty or not guilty? Talking to you.
Yes.
Are you pleading guilty voluntarily and because you are guilty of what this alleges?
Yes, sir.
Hmm?
Yes, sir.
Sir?
Yes, sir.
Okay. And do you understand? I'm sure Mr. Dusser is a very smart man. Talk to you about, you don't have to do the punching. You can be part of the whole fracas. And videoing it is obvious y'all are working together. But when you know something is going to happen and you help or take part in it, you are held just as responsible as the person who's punching. You understand?
Yes.
So fix this. Let me show you what's marked as State's Exhibit 1. Did you sign that?
Yes, sir.
Voluntarily, understand it, discuss it with your attorney, or the contents true and correct?
Yes.
State's Exhibit 1 is tendered into
No,
evidence
sir.
without objection. It's
Do you
admitted.
plead?
Among other things, this states you were mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, and cross-examination of witnesses.
Studio microphone, let that number sink in for a second. $47,540.30. That is the total restitution owed for injuries to a man who is just sitting in a barber chair. Broken jaw, facial injuries, head trauma. And here's the legal kicker. Under Texas law, both defendants are jointly and severally liable for the full amount. That means even if the other guy pays every single penny, this defendant still legally owes the entire $47,540. The court may split it in practice, but the law holds both fully responsible. That one video cost them everything.
You are totally satisfied with the representation provided by your lawyer. All of this is true, so help you God. States Exhibit 1 is made a part of the record for all purposes. Please answer for what?
Yes, sir.
Anything else to add?
Yeah, I'm sorry.
If nothing further, I'm going to find you are pleading guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I'm going to defer any finding of guilt and place you on deferred or unadjudicated probation for 10 years. There will be terms and conditions of probation, which are normal and customary for this type of offense, although this is a rare type of set of circumstances. You must pay a fine of $500. Restitution will be owed. Total.
Studio microphone. And here is where the drama hits its absolute peak. The defense attorney just told the judge, Your Honor, he's a high school senior. He's graduating in May. Can we delay the jail time? And the judge didn't even blink, said no, then paused, and introduced something called shock probation, where the court sends someone to jail for a short, sharp period as a wake-up call, then evaluates what happens next. It's a real legal tool used specifically for younger defendants. The judge isn't being cruel here. He's being calculated. This is tough love with a law degree.
This is a total amount of restitution
That is the
in this event
Yes.
of $47,540.03. I intend for that to be shared between the two parties, but we're going to see what happens on the other case. You are responsible for the full amount as well as the other person. And what generally we do is when there's two people involved, they share the responsibility. But the law states both of you are responsible for the full amount to be paid. However, both of you can pay it, but the total amount is $47,540.03 from the injuries, I guess, occurred. That's a pump. That's terrible. That's why it's a serious event. Have you ever been arrested before?
This is least.
Other than this?
Nothing.
Let me tell you, this is just a serious set of circumstances. This is terrible for many ways, but for your vulgar way you spoke and the way you spoke when you were videoing this, it makes it sound like this is something you do regularly, which isn't not part of what the United States of America stands for. You're going to jail. I can put you in jail for 180 days, 6 months. I don't put up with this. Anybody tries to do this, they're going to be sent a message the same way. They're going to jail.
Studio microphone. And that right there is how this hearing ends. Not with just a sentence, but with a lecture that this judge clearly meant from the bottom of his heart. He's talking about race, about language, about what this county stands for, about living peaceably together. 10 years of deferred adjudication. 180 days in county jail starting Friday. Over $47,000 in restitution. All because of one video, one barbershop, one senseless attack. The victim got his jaw broken. The defendant gets his future broken. And the judge made sure everyone in that courtroom understood exactly why. Share this if you think more people need to see how fast one bad decision can unravel everything.
This puts us back in time, and that's not where we are. We've progressed. We're better than this. Do you understand? As a condition of your probation, you're serving 180 days in the county jail.
Your Honor, could I ask one thing concerning that? He's a high school senior graduating in May of this year.
He's being held accountable as an adult under the law, and that's the way we're going to deal with it.
If we could postpone any jail time until weekends or until he graduates, which would be May of this year.
This is the problem you have when you do something like this. It fouls up everything, including your education and your future. That's why you try not to make foolish decisions like this. And this is about as foolish as it gets. No, he's going to jail. But there's a shock probation method that the court uses as well. You know what I mean? Okay. But you do this, you go to jail. When are you supposed to be in class next?
Tomorrow.
You're going to report to the county jail on or before 6:05 p.m. Friday. You understand?
Yes.
Or else there'll be a warrant for your arrest and there'll be another charge filed to begin that 180 days. Then I'll see. I'll see what happens before Monday morning. Have you ever been in jail before?
For this, yes, sir.
For how long were you in?
1 night.
How'd that work out for you? Was that? It's not supposed to be enjoyable. It's terrible, Wilson. The person who was pummeled, what's his status? And that person's status now?
He's recovered for, as I'm aware. He's submitted his medicals, and that's how we got them out for the restitution.
What were his injuries?
Jaw, his face. I know his jawline was broken, and
Jaw was broken.
something with his face, his mouth, facial, head injuries, and jawline.
Head injuries, jaw, facial injuries.
Mhm.
Don't ever speak like that again in public. All of this is stir up trouble. We're better than that. We're supposed to live peaceably together. People who stir up because of race or any other reasons, and this is what this sounds. This is just terrible language. That's That is not what makes a peaceable, happy place. And that's not what just this county is supposed to stand for, because it stands for better. You understand?
Yes,
sir. See the probation.
Now, this is the probation officer. They'll take you to the, what was the restitution?